Without further ado, I'll get to our first paper, which talks about a surprising trend that we've seen lately towards some common sense from the courts in sports and rec liability cases. And I think you'll find it interesting. Our first speaker is Grant Ferguson, and after him will come Laurie Graham. Both of them are athletes in their own right in the high-risk and high-reward sports of Shotokan karate and horseback riding. I won't say which is which, but we'll start with Grant this morning. Grant?
Thank you very much, Frank. Good morning, everyone, and welcome. Thank you for joining us today. 2020's been a year of incredible change, hasn't it? We've all had great difficulty adapting to this new normal, but 2020 has also had a significant positive change, both in how seriously we take our health and in the significance of sports and recreation in our more isolated lives. Outdoor parks and trails are now our primary destinations for exercise. Gyms and fitness centers are flashpoints of controversy. They're headline news, both because of how important they are to us and because of our greater awareness now of the potential risks they present. It's fortunate then that 2020 has also brought us some clarity in how these risks can be assessed. We've seen how the standards and risk liability plays out this year in sports and rec cases. Whether it's the standard for what should be a proper outside park or trail, or whether we can protect ourselves with waivers and the limits of those, or even just how to evaluate risk among many different types of sports, 2020's been a year of significant change in this area of the law. Well, today we'll look at all of those areas. We'll explore how the goalposts have moved, and we'll bear witness to some great plays by the defense in sports and recreation cases. To begin, I'm going to talk about the new rules and the new goals that have come out this year, specifically with regards to liability waivers and the standards of risk in sports and rec. To do this, I'm going to start with a case called Hosekani and QK Fitness. This was a Court of Appeal decision in Ontario this year. It dealt with the use of waivers and the doctrine of obvious risk that applies to low-risk sports. Then I'll talk about a case somewhat different, that of Casterton and McIsaac, which was a trial decision released this year. There they talked about high-risk sports and what we've come to know as the fair play doctrine and whether that should control high-risk sports going forward. Then you'll hear from my colleague Laurie Graham. She'll talk about some great plays that have been made this year, specifically in occupiers' liability in sports and rec cases. She'll start with Section 3.1, the double reasonable standard, the one that applies to most cases, and the case of Onley and Town of Whitby. Then she'll move on and she'll talk about 4.1 of that same act, voluntary assumption of risk, and the case of Karpoutzis and the City of Toronto. So let's dive in and talk about what the new rules and new goals are that have come from cases this year. To start, let's talk about liability waivers in sports. Waivers are sometimes not worth the paper that they're written on. Even though the wording may be in a contract, it simply may not be accepted as part of a contract for other services. They are allowed in Ontario, and in fact, they're codified in that same Occupiers Liability Act. Section 5.3 of the Act allows an occupier to restrict, modify, or exclude any duty of care so long as certain conditions are met. It's a fairly powerful provision that's relatively underused. But the key for a waiver to be valid is the adequacy of notice. That notice has to be given at or before the making of the contract, and it must be given by the party that benefits from the waiver. This is law that's been fairly well established in Ontario. Since 1991, the Court of Appeal has ruled in the case of Trigg and MI Movers that this is essentially the approach we should follow. They reaffirmed that decision in 2008 in the case of Best and Deal. The fights since 1991 have been in what adequate notice actually means. What's changed this year is that maybe now we have a set of rules to settle those disputes. The second major issue we'll talk about today is liability standards in sports. Typically, liability and standards of care are based on the level of risk that somebody assumes. In sports, this breaks down into two general categories. The first is unskilled activity. This expressly includes gyms, cardio classes, fitness classes, and tennis. These sports have been labeled with an obvious risk doctrine, where obvious risks do not require warnings. They're different, though, than skilled activities. This is a separate class of sports. It involves tackle football, gymnastics, and hockey expressly in the case law. Since 2015, we've relied on something called the fair play doctrine to determine what the proper standard of care is. But maybe that's changed, and maybe now we're dealing with a rules-based doctrine. So let's look at the first case. This is that of Hosakani and QK Fitness. It was a Court of Appeal decision on a summary judgment motion from 2019. The facts of the case are that the plaintiff sustained a very serious injury to her spine after slipping on a round dumbbell in a fitness class. The round dumbbells were given to her by the gym. The plaintiff was instructed to put them down. The plaintiff was instructed to then step on a small exercise platform and to continue to perform the exercises in the cardio class. The plaintiff was then told, step to your right. She steps to her right and trips on a dumbbell that was unexpectedly there. It had rolled there from the position that the plaintiff put it there. The plaintiff had also signed a waiver of liability as a condition of her gym membership. So the gym and the instructor brought a summary judgment motion seeking to strike the entire claim. So what did the court do? Well, the court threw out the waiver. Such a clause was contemplated, the court agreed, by Section 5.3 of the Occupiers Liability Act. But in this case, the waiver wasn't executed correctly. Section 5.3 does allow an occupier to modify what the standard of care is, but it also requires that same occupier to take reasonable steps to bring such a restriction, modification, or exclusion to the attention of the person signing. In this case, there was no evidence from the contract that there was anything special about the waiver. The waiver was simply another set of words within a very lengthy standard service contract. It was buried in fine print. And there was also no evidence from any employee that this was ever specifically drawn to the attention of the plaintiff. So what did the court do? Well, aside from throwing out the waiver, it went further. It set clear goals for how a waiver might be valid and what we can do differently. The court provided specific examples of what good waivers look like, and here they are. From these examples, we can see some general trends, as well as we can take these very specific examples and advise them to our insureds and companies that this is really what you should be doing if you want to draw your attention to a waiver. Some general things we can take away is that the wording doesn't really matter. The wording could be anything from warning to please read carefully to something very expressly talking about legal rights and waivers of liability. What is important is that the headings be bolded, that they can be in a different colored font, that they can be underlined and somehow capture the signatory's attention so that there is some evidence that they were aware of the waiver. More than just the drafting of the contract, though, the court gave us specific actions that occupiers can do to ensure that their waivers are valid. They can have the plaintiff or potential plaintiff sign the specific provision. They can have it witnessed. They can have the employee witnessing or working with that plaintiff provide evidence that they specifically drew that clause to the plaintiff's attention. And what's great about this case is that it is very clear that any of these features would satisfy the requirements of Section 5.3 of the OLA. So aside from throwing out the waiver, the court then had to consider what should be the standard of care in this case. From the plaintiff's perspective, it should be a very high bar. Instruction was provided by the instructor of the gym. She was told what to do. She followed orders. There was really no responsibility the plaintiff wanted to take for the accident at all. While that might seem a little bit weak, there is case law to support it. The case of Thomas and Hamilton City Board of Education is a 1994 Court of Appeal decision. It related to tackle football, and it said essentially that a plaintiff could rely on being told what to do and had full trust in their instructor. But the defendants took a different tact. They said no warning at all was needed because this was an obvious risk. Risks could be obvious if you could evaluate them without unreasonable risk of harm to you. And there was case law to support that as well. The defendants relied on the trial decision in Jocelyn Hillcox. It wasn't a court of appeal decision, but it did say that if you're going to play a game or conduct a sport where you reasonably know there's a hazard, that hazard does not have to be warned. The court accepted that a fitness class was not a high risk or an inherently dangerous activity. The reason they did that was that there was simply no evidence that these dumbbells were inherently dangerous. The plaintiff had used them dozens of times herself. They had actually been used hundreds of times by the gym in the various classes. An occupier does not have to warn an adult of an obvious risk. But the court also put a proviso on that. This applies to low-risk sports. So how do we know if a sport is low risk? Well, low risk can now be defined. It doesn't require any specific skills or instruction. It doesn't need any progressive development of specific skills. The skills themselves are simple and rudimentary. And if you can classify the activity as that, this is a low-risk sport, and obvious risks do not need to be warned against. So what do we take from this? Well, this was affirmed by the Court of Appeal this year. It's now good law in Ontario. There are now clear rules that have been sanctioned for waivers, both on how they're drafted and what steps can be taken beyond the contract to execute them. The good news is that this provides us clear goalposts on how to draw attention to the waiver to help make it valid. There are now also new rules as to what is an obvious risk and how do we define a low-risk sport so that we can use that defense. The definition of low-risk sports now does not require specific instruction or the progression of skills. The skills themselves are simple and rudimentary, and then you have a low-risk sport. And the best news of all is that the patent risks of injury in low-risk sports are not recoverable. That was a good news story. I think we all needed one. But we're going to contrast that slightly with the second case of Casterton and McIsaac. This is a trial decision of Justice Sally Gomery. It took place during a hockey game where the plaintiff was injured in an in-game collision with the opposing hockey player defendant. The plaintiff was knocked off his feet. He hit his head and lost consciousness and sustained a rather serious injury. He claimed he was blindsided, and the defendant claimed it was an accident. This was an admitted beer league of men in their late 20s. There was some athleticism there, but this was nowhere near a professional league. It was very casual. There was a finding of gross misconduct on the play-in issue, but there was also conflicting evidence. It was accepted only that the defendant was moving and the plaintiff was not. So what did the court do with that? Well, as in many decisions where the court wants to move the goalposts, they started with the history of the standard of care. Justice Gomery went all the way back to 1965 and the case of Agar and Canning. Then, a right of recovery required deliberate intent on the part of the defendant, a definite resolve to cause serious injury. That was a mental component that it was up to the plaintiff to prove. And it was agreed that if this case arose in 1965, there would be no way that there would be liability on the defendant. But that standard changed in 1991 in the case of Sexton and Sutherland. There, it wasn't the mental component of the defendant that was an issue, but simply that there was a great force and a reckless lack of regard as to whether serious injury was caused. What that means is that we've moved from a mental component into something involving recklessness, which is a higher standard than negligence. That didn't last very long, though. And by 1994, the standard in Unruh and Weber was that it simply needed to be an injury caused by what fell outside of what a reasonable competitor would expect. The key word in that decision was reasonable. That brought the standard now into negligence for high-risk sports. And finally, in 2015, Justice Firestone made a decision in Levita and Crew, where he held that the injury needed to be out of the ordinary. It needed to be beyond the bounds of fair play. And that generated what we now know as the fair play doctrine. He listed several factors, including type of league, level of play, applicable rules, and nature of the game, to help define what that fair play was. Generally, the riskier, the higher the standard of care. What the court did was it started with defining the act. The act it accepted was a blindside. The court then went to the rules of this particular league and found that those rules hold blindsides to be absolutely prohibited. By virtue of the defendant having injured the plaintiff with an illegal move, there was then liability on the defendant. Nothing else was necessary for liability. The court accepted that the hit wasn't intentional. They accepted that it wasn't reckless. But factors that Justice Firestone had raised, as it being a casual league, the type of injury being foreseeable, as it was a body check in a hockey game, and the risk that such an accident actually happened were low, were discarded. So what do we take from this? Well, in one sense, this case continues the downward trajectory, lowering the bar for successful negligence in high-risk sports. But what it also does is it's changed the fair play doctrine. A violation of the rules of the game leading to injury was all that was required to find liability. Issues like intent, quality of league, expectations of players, or foreseeability are no longer required or protective factors. If we contrast that to the Hosen-Canny case, obvious risks in a sport that is high risk cannot protect defendants. So how have the goalposts moved in 2020? Well, we've seen in Hosen-Canny, we now have clear rules and paths forward for waivers and how they can be drafted and how they can be enforced. We now have a better definition for low-risk sports, and we understand that that involves no specific instruction or progressive development of skills. We now can apply this to very specific cases, but we can also expand that to other cases that don't have cases. Other obvious risks has been upheld as a doctrine. It protects against having to warn for patent hazards. But in contrast to that, we have Casserton relating to high-risk sports. The goalposts have moved now and increase exposure on defendants. Liability can exist even where injuries are foreseeable, probable, or obvious. The fair play doctrine has also now been expanded to include any breach of the rules that leads to injury. Higher risk sports have new goals and an easier target for plaintiffs to reach. All is not lost, though. Soon we will hear about some great plays from the defense in occupiers' liability and sports and recreation. But I'll pause for a moment and ask if there are any questions I can answer.
Thank you, Grant. We do have one question that just came in regarding waivers. And the question is, what would happen if the person signing the waiver does not speak English as a first language? In that case, would bringing their attention to the waiver still be enough?
Not likely. So again, the standard in Section 5.3 is that it must be a reasonable attempt by the occupier to draw attention. Reasonable is one of those magic words, as we know, that applies to many different circumstances and the totality of circumstances. So in that case, I think a lack of understanding would simply make pointing at the words that were meaningless also a meaningless gesture. So I don't think that that would actually be a reasonable step. I think that what they'd have to do is they'd have to allow for some sort of translation to be available if that was to be a reasonable step and so valid under 5.3.
Okay. Thank you very much, Grant. We're going to now switch over to Lori's part of the paper, and Lori will discuss occupiers' liability type of claims in these recreation cases.
Thank you, Frank, and thank you, Grant. So what we'd like to do with the remainder of our time today is look at what we're calling great plays. These are case studies from 2020 in which the defense was successfully able to avoid a finding of liability. So as we look at these cases, what we want to do is look at the specific strategies that were employed by the defense in achieving these winning results. And as we look at those strategies, we want to try and tease them out and articulate them in a way that can be applied more universally in the sports and recreation context. But before we do that, let's take a look at the Occupiers Liability Act itself. We do this as a way of kind of brief background and overview. So the Occupiers Liability Act imposes a statutory duty of care on occupiers. 2 points about this generally. One, that statutory duty replaces any pre-existing common law duty that might have been owed. 2, that duty is not absolute. What's the content of that duty? Well, it's going to depend on which subsection of the Act applies. So we're going to look at 2 sections today, Section 3 and Section 4 of the OLA. First, with respect to Section 3, this is what we might call the general occupier's duty, and it applies in a number of different circumstances, including sometimes in the sports and recreation context. Under Section 3, an occupier has a duty to take reasonable care with respect to the safety of persons on the premises. In short, liability requires that the risk be foreseeable by that reasonable system of maintenance that's been put in place by the occupier. In contrast, we're also going to look at Section 4 of the OLA. This is what we call the sort of risk willingly assumed section. And under Section 4, the Act holds that where a risk has been willingly assumed upon entrance to the premises, then that positive duty to take reasonable care that we looked at in Section 3 does not apply. In fact, there is no positive duty to act on the part of the occupier. Instead, the occupier is under a negative duty not to do certain things, specifically not to do 2 things. The first, not to act with deliberate intent to do harm. We're not going to look at that today because that's fairly specific and not very often seen. The second, and what we will look at today, is to not act with reckless disregard for the presence of the person on the property. So this year, there have been 2 cases that we're going to say have moved the goalposts in favor of the defendants. The first case is the case of Only and Whitby. This is a trial decision that deals with the application of Section 3 of the OLA. That's that higher positive duty on an occupier to take reasonable care. In particular, what we're going to look at in that case is the way in which the defense was able to draw a distinction between the foreseeability of the risk in general and the foreseeability of the specific damage that was caused and the specific injury incurred. Do that to their success. The second case we're going to look at is the case of Carpuzes and Toronto. This is a summary judgment decision that deals with the application of Section 4 of the Act. That's that negative duty not to act with reckless disregard. In particular, in that case, what we're going to look at is the way in which the defense was able to shape the characterization of the risk in a way that was helpful to its case. In both of these cases, we're also going to spend some time looking at the specifics of the maintenance programs that were in place and the extent to which the court does or does not impose additional obligations on those systems of maintenance. So let's get into it. The first case we're going to look at, this is the Only and Whitby case. This is a trial decision, and again, by way of reminder, this is a case that deals with the application of Section 3. This is the positive duty to take reasonable care case. So what are the facts? The plaintiff is a teenage girl who attends a municipal park to play a game of soccer at night. The game takes place, as you might imagine, under the lights. The lights are turned on and functioning when the plaintiff arrives. At halftime, the plaintiff leaves the field and sits down on the grass beside one of these light posts. As she gets up, she exclaims that she feels as though she's been shocked. The plaintiff returns to the field briefly, but then collapses and is hospitalized with injuries to her legs and feet. So what happened here, first and foremost? Well, the court accepts that the light pole, which she sat next to, likely malfunctioned as a result of a lightning strike that had caused insulation within the pole to melt, and the result was that electricity had seeped into the surrounding ground. With respect to maintenance, the town and the Electrical Safety Authority did conduct yearly inspections of the light posts, and in this case had done so approximately 40 days prior to the accident. But at the time, there were no deficiencies evident. So, the question here, given the cause that's been accepted, namely that lightning strike theory, is whether or not that was reasonably foreseeable. And so by way of sort of overview, the court gives us a rearticulation of the standard established by the Supreme Court of Canada in the 2018 Rankin decision. The Rankin decision is helpful for the defense insofar as it explicitly articulates that reasonable foreseeability and possibility are not the same thing. It takes for granted that any harm that occurs is by definition possible. So we can say any harm that's going to give rise to legal action is by definition possible. But reasonable foreseeability is a higher threshold than just mere possibility. So what does that mean in this case? Well, again, as we've seen, the court accepts the theory that the damage to the light bulb was caused by a lightning strike. It goes further and says that when a light post is damaged by lightning, the expectation by a reasonable person is that there would be some outward sign of malfunction or damage. In this case, there was no such sign. The lights were on, they appeared to be in good working order, and they were illuminating the field. So in this case, there was no external indicator of damage. And for that reason, the damage was highly unusual. Although, and this is the distinction that the defense is successfully able to rely on, although the risk itself was foreseeable, which is to say, although it was foreseeable that a light post might be struck by lightning, the type of damage, i.e. this unseen electrical current that would then shock a player sitting on the ground, was not. And so on that basis, the defense is able to avoid a finding of liability for the town. Now, even though the court might have stopped its decision here, because there was no finding of liability under Section 3, it goes at some length into a discussion of the maintenance program. The plaintiff's argument was that the town of Whitby ought to have had a system in place that looked out for and attended to the risk of this electrical leakage problem. Why did they say that? Well, they pointed to the City of Toronto and a program that the City of Toronto had in place to replace specific components within their streetlights after it had come to their attention that there was a similar problem with electrical leakage. The plaintiff's argument was, you see, here's a program that another municipality implemented with respect to its streetlights, and therefore it's reasonable to expect that the town in this case would have had a similar system in place. The court rejects this argument, and so let's look at why. The court says, so long as the maintenance program in this case would have caught a sort of normal defect with normal outward signs, it was okay that it missed this specific issue. If there had been an evidence that there was a stray voltage problem in the past, in this context, then it might have been the case that a more rigorous program, like the one we see in the Toronto Streetlight program, might have been required. But it was up to the plaintiff to establish this, and in this case, they could not. As always, again, the court looked at cost effectiveness and found that it simply wasn't cost effective to have this kind of program in place in the absence of obvious and specific evidence of a past problem. So what's the takeaway? So in this case, in the sports and recreation case context, less frequent, less rigorous testing is acceptable when compared to, for instance, the maintenance program required for city streetlights. The sports fields have a lower standard of care. Why is that? Well, let's just think about it. When you're talking about city streetlights, those are going to be used continuously, they're used year-round, and they're subject to relatively extreme environmental conditions given their location within the city. None of those apply in the case of sports fields, and therefore it's reasonable and acceptable for the maintenance program to be less rigorous and less frequent. So what do we take away from this with respect to Section 3? It's the plaintiff's burden to prove foreseeability. And it can't do that by simply just saying, well, there was a system in place for inspections and it missed this issue. Again, possibility is not enough. In a case where you've got unusual, visible, or exceptional issue, then the system can still survive and discharge that Section 3 standard. You can see that's the kind of language that was successful on the defense's part: unusual, invisible, and exception. In this case, we see, again, plaintiff really loses the ability to establish liability and prove its case without the ability to point to some sort of separate evidence of a known problem. And so as we said, this is a great play for the defense. Why? Because we have an affirmation from the court that there is that lower standard in place for sports facilities, even in this case a facility that's municipally owned, than other types of municipal properties, for instance, sidewalks and streetlights. All right. Let's move now to the second case we're going to look at this morning. This is the case of Karpuzes in the City of Toronto. This is a summary judgment motion written by the always pithy Justice Perel. Now, in this case, the applicable section of the OLA, just to go back to that, is Section 4. So this is that negative duty not to act with reckless disregard. So what are the facts? As you said, this is a summary judgment motion, and as you might expect, it's granted in the favor of the city. The plaintiff was an experienced skateboarder who enters a Toronto City Park at 2 a.m. on a clear, dark summer night. He travels down an unlit, paved path, portions of which are covered with significant tree cover. During the day, the city maintained and inspected the trail, but at night, the trails were not deliberately lit and no inspections took place. As the plaintiff is traveling along, he encounters, as he reports, some uneven terrain, and possibly as a result of debris on the trail, and his wheels jam. He falls, strikes his head, and suffers a significant brain injury. So what does the court do in this case? Well, as we said, this is a Section 4 case, so this is a risk voluntarily assumed case, and that's the standard that applies. Now, why is that the case? Well, as it just so happens, in a section of the Section 4 of the OLA that we didn't explicitly look at the outset, there's a provision that provides that when the harm occurs on a recreational trail, there's a presumption that Section 4, that lower standard, applies, so long as the trail is properly posted, which in this case it was. So when the individual enters the premises for the purposes of recreational activity, including a recreational trail, then we get, according to the Act, this lower Section 4 standard imposed on the occupier. That's that lower standard not to act with reckless disregard for the presence of the person on the property. When that's the case, there is no positive duty to take reasonable care of the premises. As a starting point, we also know that reckless disregard, the court holds, is a higher bar than just carelessness or negligence. The standard is that the occupier must be shown to have known or should have known the injury was likely to happen. So known or should have known the injury was likely to happen. That's how we get to that reckless disregard. So what does that mean in this case? Well, to start, the court gives us a list of actions or inactions on the part of the municipality that explicitly don't rise to that level of reckless disregard. Those include not posting signs warning of the hazards of nighttime use, not lighting the trail at night, and not just outright closing the park or posting signage prohibiting nighttime usage. Justice Perel goes on to say that pedestrians like the plaintiff don't need to be warned of obvious conditions. For instance, in this case, that a trail that's unlit might be in places quite dark during the night. There is no disregard for inherent risks such as darkness at night by keeping a trail open. We have this language of inherent risk. We also have this language of normal risk. Justice Perel finds that a skateboarder, like the plaintiff, should have known that the possibility of encountering uneven terrain or debris on a trail that might result in locked wheels was a normal risk that should have been known to the plaintiff upon entry to the premises. And because the accident was caused by this combination of normal and inherent risks, by this combination of the normal risk of debris on the trail and the inherent risk of darkness at night, those risks were taken to be willingly assumed by the plaintiff. So what do we take away from this case? So in this case, with respect to maintenance, weekly inspections of the trail during the day were sufficient under this lower Section 4 standard. There was no breach of that standard because the conditions were reasonably known on entry. The plaintiff knew that he might encounter uneven terrain and he knew that it might be dark. Therefore, that risk was deemed to be foreseeable and therefore assumed by the plaintiff. One last thing to note. This is a summary judgment motion brought by the city. The plaintiffs had retained an expert to opine on the lighting conditions on the trail, the conclusion of which was that there might have been significant variations in the lighting on the trail that could have been disorienting to a user of the trail at night like the plaintiff. Although this is a summary judgment motion, which means although the defendants had the burden of establishing that there was no genuine issue for trial, it was not required that the defense retain an expert to respond to this plaintiff opinion on lighting. Instead, Justice Perel held that it was sufficient, common sense was sufficient, to say that it should have been known that, of course, there might have been low or poorly or non-lit at all sections of the path, and that there was no need for an expert to say as much. So what do we take away from this, both of these cases? I think 3 things we can take away about the Occupiers Liability Act and how our obligations under it have changed in 2020. 1, as we've seen, that duty of care imposed by Sections 3 and Section 4 in neither case is absolute, not even under that higher Section 3 standard. With respect to Section 3, it's the case that standards have been lowered in the case of sports and recreation actions, in such that lower systems inspection and maintenance are supported, systems that may not even detect the plaintiff's issue. And that's the case, as we've seen, where the issue can be described as unusual or unseen or otherwise an exception to the rule. And finally, in the case of Section 4, where a risk may be voluntarily assumed for something caught by a risk can be voluntarily assumed at night, even where that same risk, namely debris on the path, might have been caught by daytime inspections. And the decision to shut down or to cease having protections or inspections in place at night is all right where the hazard is still patent before entry. So that will do it for us this morning, unless there are questions from Frank.
So one question that came through, Lori, was whether the Whitby case, the first case you spoke about, was decided under the Occupiers Liability Act, or whether there was another act that applied on the standard of care that Whitby had to live up to.
So it was decided under Section 3 of the Occupiers Liability case. There was also, no, there wasn't a nuisance case in that case. It was decided under Section 3 of the OLA, and that was the only basis that they pursued for liability in that case.
Okay, that's it. Thank you very much, Lori.